Hello, everybody. Welcome to WG University, which is Weber Gallagher's series of educational programs. This is our commercial transportation webinar series. My name is Jim Wesco, and I'm presenting today from our Philadelphia office. If you'd like to view this webinar again, or share it with others, or see our other Weber Gallagher University programs, please visit the Weber Gallagher website at www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at wglaw.com. I'm here today to talk about the Food Safety Modernization Act and how it specifically applies to transportation entities in the supply chain. Again, my name is Jim Wesco. I'm a partner here at Weber Gallagher in Philadelphia, and I thank all of you who have joined us on a Friday afternoon. We'll get done in time so that those of you who have early tea times will be able to make it without any incident. So thanks for coming. Again, we're here today to talk about the Food Safety Modernization Act and how it applies specifically to transportation entities. The actual law itself was signed back in January of 2011 by President Obama. It's an incredibly broad law, and it applies to a lot more than just the transportation and supply chain aspect of food delivery. The actual intent and effect of the law was a reaction to September 11th and the fear of, excuse me, of bioterrorism, and it covers the complete production of food, literally from the time the seeds go in the ground to when they're fertilized, to when they're processed and packaged and checked for quality. And what we're here to talk about is the last link in the process, which is actually how it gets from the processor or the manufacturing facility to the consumer. The actual components that deal with the transportation aspect of it came into effect in June of 2016, so about a year ago. The final rule that actually went into effect on April 6th of 2017, and we'll talk a little bit about what the Act applies to and who it doesn't apply to in a few minutes. I just want to give you a brief outline of my presentation so you know what we're going to be talking about today. I want to just give you a brief history of the Act, where it came from. I want to talk about the scope and outline of the Act. I want to talk about when it became effective and what's still to come down the pipe with respect to effective dates. I'm going to talk about to whom the Act applies, and most importantly, what the Act says, and the issues that the Act creates for brokers, shippers, and carriers. Finally, I want to talk about some case studies on issues related to food contamination and what constitutes damage at delivery. And finally, if we have some time, I'll just make some brief comments about insurance and how it applies to the whole process. The Act is incredibly broad. It basically, if the product is covered by the Federal Food, Drug, and Cosmetic Act, subject to a few exceptions, which we'll talk about in a few minutes, the Act applies to that. The actual language of the let me just change there we go. The actual language of the Act, again, the section that's applies to transportation is Section 111 of the Act, and in it the Congress set forth what's supposed to be done with the implementation of the Act. For those of you not familiar with how laws are passed in Congress, once the law is passed, that's just the beginning of the process. It takes several years, usually, and in this case it took almost 5 years for the law that was actually signed by President Obama to become enacted by the implementation and the adoption of actual rules. And as I talked about before, the Congress is tasked, or the federal agencies are tasked with writing rules. There's a whole rulemaking process. Industries get a chance to sound off about whether or not the rules are fair and reasonable, or how they should be changed. The lobbyists and lawyers get involved, and it's not until several years, in this case about 5 years later, does the actual um, the rulemaking process and the regulations that enact and enforce the law go into effect. So that's where we are now. Just a little bit about the history. This all goes back to about 1938, which is when the Food, Drug, and Cosmetic Act was enacted. In 1990, there was the Sanitary Food Transportation Act. Again, September 11th happened, and there was a fear of bioterrorism, and Congress was sought to remedy that situation and look to prevention rather than reaction when it comes to foodborne illnesses and things like that. I think it's just to give you an idea of the scope of what we're looking at when we're talking about foodborne illnesses. Every year, about 48 million people contract some type of a foodborne illness, and several hundred thousand people actually receive medical treatment, and thousands of people actually die from this stuff every year. And it's Congress's intent when they made this act to prevent these things from happening rather than react to them once they do. Okay. Again, the actual proposed regulations didn't start coming into effect until February of 2014, and because of the broad scope of the act, a lot of those initial regulations had to deal with the production process and how the food is actually farmed and processed. And now that we're at the end of the process, we get to the supply chain. Now we're talking about the transportation process, which is what we're here to talk about today. So, a brief summary of what the Act entails. It's basically set up to establish a broad range of controls for the transportation of food products. Um, it deals with what type of equipment is required. It deals with how temperatures are supposed to be managed and set. It deals with how records are supposed to be kept from the motor carriers, the shippers, the brokers, and we'll talk about who the Act applies to in a few minutes. It also talks about training, talks about how, and the Act also has a large component about enforcement and monitoring, which we're not going to get into here. It's safe to say that enforcement and monitoring aspect of the Act itself is still way far down the pipeline. The initial protocols for inspecting or monitoring on the transportation end is every 5 years, and they haven't even begun doing that yet. So what we're talking about now are the regulations, not necessarily the enforcement aspects of it. One thing I wanted to talk about briefly is a discussion of the Act itself and what the initial ideas and thoughts were about the Act when it was first proposed and then first signed by President Obama. The initial thoughts from the transportation industry were that this was going to be an Armageddon type scenario with respect to liability for motor carriers for food shipments. But as it turns out, it's really been much more benign in that regard. As we'll talk about in a little while, the Act puts a large amount of the responsibility for the safety of the food in the supply chain upon the shippers and brokers. And the motor carrier community was very concerned, and the insurers as well, were very concerned that this Act, as originally contemplated, would create an absolute liability regime against motor carriers that would give the shippers and receivers carte blanche or an unfettered and unlimited ability to reject loads based on the slightest fear that something may have been adulterated. But as it turns out, and we'll talk about, that's not what happened. It's far more benign, and commentators have stated when evaluating the Act that the motor carrier community was actually doing cartwheels when they found out what the Act actually said. And it's the shipper and broker community that really are bearing the lion's share of the burden here. with respect to the requirements under the Act. It's important to note, too, as just an introductory comment, that the Act, and I want to just call it the FSMA Act, the Food Safety Modernization. We'll refer to it as FSMA from now on. It's easier to say. The Act is not a liability regime. It doesn't replace the federal statutes that control liability for loss or damage to food products in interstate transportation. Right? That's the Carmack Amendment, as I'm sure most of you know. This is not, the issue here isn't whether or not a new set of standards for liability is to be enacted against motor carriers. The issue here is more along the lines of, if the carrier fails to adhere to the shipper's requirements as set forth in the Act, does that create a prima facie case of liability against the motor carrier? And as we'll talk about a little bit later, there were comments in the rulemaking process that suggest that that is definitely not the case. So from a motor carrier standpoint, what looked initially to be a very bad statute and a very bad regime for motor carriers has turned out to be quite the contrary. The scope of the FSMA is quite broad. It applies to motor and rail shipments. It is not just interstate shipments. It can apply to intrastate shipments, which are shipments from a point in one state to a point in the same state. The goods don't have to cross state lines to be applied, to have the Act apply. It does not apply to ocean or maritime or air shipments. However, if the goods come in on a ship or through the air and then get transloaded onto a motor carrier or a rail carrier, then the Act applies. It's basically the scope of the Act is intended to apply to specified goods that are delivered inside the United States for consumption. It's basically deals with goods that are open to the air in unenclosed containers. It's for food or ingredients. It's bulk items in a tanker. It is for temperature controlled products. It does not apply to frozen products. It applies for, like I said, consumption in the United States. It covers exports, something that's processed and loaded for delivery from a point in the United States to a dock or a pier or a railhead for transportation outside the country. The Act ceases to apply once the goods are placed on the rail car or placed on the ship and they be exported to other countries. Goods that are transshipped through the United States, say a rail shipment of flour tortillas that originate in Mexico and get transshipped through the United States to Canada, are not covered by the Act. That's what transshipment's called. It's basically going through the United States, starting somewhere else, going through the United States, and then ending up somewhere else. Basically, with exceptions we'll talk about, if the specific good is described in the Federal Food, Drug, and Cosmetic Act, save a few exceptions, that product is covered by the Act. Recently, some of you may have seen that the government issued additional exceptions to goods or products subject to the provisions of the Act. I'll just go over these very briefly, and I'll talk about the other exceptions in a few minutes. The first one is applies to grade A milk, and basically the government said if there are other regimes, if there are other state or federal statutes that cover particular products, we're not going to have the FSMA apply to these. And one of those is for grade A milk, so bulk shipments of grade A milk are not covered by this. Supermarkets or restaurants that have their own transportation and transport their own goods, say from their own processing centers or their own distribution centers to their retail outlets for sale directly to the public, are not covered. So if you have an Albertsons or a Wegmans or an Acme or something like that, and they're transporting goods from their distribution centers to their um, uh, stores, that they would not be covered by the Act. Restaurants as well. You see the Dunkin' Donuts trailers or McDonald's trailers, or for Breaking Bad fans, a Los Polos Hermanos truck who provide goods from the distribution centers to the retail restaurants would not be covered. Also recently added were shellfish, oysters, clams, and mussels. The Act doesn't apply to live animals, and the original way the Act was drafted was that it didn't apply to live animals except for shellfish, but I guess the shellfish lobby is very powerful, and they recently changed that to include shellfish, so it doesn't apply there as well. I just want to go step off my PowerPoint for a second and talk about some of the other exceptions. Farmers are exempt from the Act. So farmers hauling their own product to processing areas are not subject to the Act. Goods that are processed and shipped for future export outside of the United States in silos or warehouses, they're exempt from the Act. Gases related to the food preparation and processing industry, such as CO2, are not subject to the Act. Human food byproducts, so things that are left over from the processing that get used for animal feed, are not part of the Act. And for those of you who have cats or kittens, and you see, if you ever buy the little cans of tuna fish and you wonder why the cans of tuna for cat food don't have pull tabs on them, it's because some of those cans end up going to other countries for human consumption as tuna fish suitable for edible consumption, and some go to the United States for pet food. But stuff like that would not be covered by the Act. Things that are completely enclosed by containers are not covered by the Act, as long as they're not temperature controlled. And again, before I said it, live food animals are not covered by the Act as well. The effective date just happened, April 6, 2017, for any business with revenues over $27.5 million. Anybody, any business or any transportation entity gets subject to the Act in 2018 unless their business is under $500,000 in gross revenues. So if you're a small business or a small producer, the Congress has exempted you if you're under $500,000. I want to talk a little bit about the parties on the slide now, who this Act applies to. Obviously, it applies to shippers. Shippers are the processors, the manufacturers of the product. It applies to the people who receive the product. It also applies to loaders, and that was not in the initial Act. It was that the term or the addition of loaders as being applicable under the Act happened during the rulemaking process, and that's significant because a loader can be an employee of the motor carrier or the shipper. It doesn't necessarily have to be either one, or it can even be an independent third party. So that's important. It does confer some duties upon somebody who could be aligned with or affiliated with the motor carrier, even though they're loading it at the origin dock. Obviously, it applies to motor carriers. It also applies to brokers and intermediaries, and for sake of definition, when we say brokers and intermediaries, they're, for all intents and purposes, the same thing. We use terms such as 3PL and 4PL and logistics providers, but any entity that arranges for the transportation of the products by contracting with or contacting the shipper and then arranging with the motor carrier is a broker. We can call them brokers, intermediaries, 3PLs, 4PLs, but they are, for all intents and purposes for our analysis, we'll call them brokers. Not included in the Act are unloaders. Some of the issues associated with the Act, or the contents of the Act, we'll just go through those briefly. One of the most important things that the Act dictates is that the protocols for transporting goods subject to the Act are largely, if not exclusively, dictated by the shipper. The understanding and argument that Congress used, or the rationale that Congress used when they enacted this law, are that these goods are the shipper's goods, and the shipper knows best how they should be transported, what the proper protocols are, what the temperature parameters should be, and things of that nature. They're the ones who control the process. They're the ones who have the power to dictate to the downstream transportation providers how the goods should be transported. Therefore, the bulk of the responsibility under the Act falls with them. They're supposed to deal with, like I said before, the temperature issues. They're supposed to deal with segregation and isolation issues. The Act deals with what the restrictions and regulations are with respect to contact with raw food. The Act is supposed to prevent cross-contamination. It's supposed to deal with allergens. Again, the carrier is primarily tasked with setting forth the requirements for temperatures and pre-cooling. The Act also deals with the need for sanitary trailers and the importance of seals, which we'll talk about in a little while when we get to the liability aspect of this. A little more about protocols and controls with respect to the Act. The idea here is, while the shipper is tasked with the primary responsibility of setting forth the parameters for safety and for ensuring the safe delivery of the product to the dock, once the motor carrier loads it, it becomes the motor carrier's responsibility. So therefore, it's very important, we'll talk about it a little bit later, that the motor carrier inspect it before it's loaded. And what we'll also talk about later is that there is a gaping hole now created by this Act, in that the Act has become law. It is now out there. Shippers and carriers and brokers are dealing with it. And as we'll also discuss later, there's not been any case law that's directly addressed any of the issues that are sure to arise as a result of the law. So therefore, there needs to be, the gap needs to be filled by contract. And we'll talk about the need for contract shortly in more detail, but that's how a lot of the issues with respect to the Act have to be addressed and dealt with, is by the shipper creating contracts with the carrier and the broker creating contracts with the carrier that deal with all the aspects of this. Because the Act requires the shipper to set forth written protocols to give to the carrier about the transportation of goods, and the best way, really the only way to do it, is by contract. The Act also deals with, in pretty significant extent, the need or the requirements for equipment, how it must be sanitary. It's the shipper's duty to specify to the motor carrier all the necessary sanitary requirements for the carrier's vehicle. Right? Obviously, the Act has specific design requirements with respect to trailers, but with respect to cleaning requirements and sanitary requirements for the trailers, that's the shipper's responsibility to tell the motor carriers. There's also issues dealing with bulk shipments. The law requires the carrier to keep records to demonstrate to the shipper how the trailer for bulk shipments has been cleaned before it's been provided to the shipper for pickup of a bulk shipment. And the carrier has to provide or has to maintain and preserve records to show to the shipper, if required, what the last 3 bulk shipments were in that particular trailer. So the law requires the carrier, again, to demonstrate to the shipper, yes, this was cleaned, this was how it's cleaned, this is how the trailer was cleaned, and this is what the trailer carried the last 3 times before we brought it over to your dock to pick up your bulk equipment. And these records have to be kept. We'll talk about this in a little while, but the record-keeping requirements under the Act are that the motor carrier keep records for a year after the shipment. Some of the issues dealing with temperature, which is a big which is going to be a big issue with respect to liability as the Act um, gets integrated and it becomes the law of the land, and everyone starts dealing with it and it starts working its way through the courts, is what constitutes a material deviation in temperatures. We've all dealt with situations in food shipments that are temperature sensitive, where there may be a brief time during the transportation when a particular product is out of temp, maybe only by a few degrees, and it's rejected at the destination by the consignee, and the motor carrier argues, well, this stuff wasn't, you haven't demonstrated in any way, shape, or form that this minor temperature fluctuation or variation has caused damage. Unfortunately, the Act doesn't address that specifically, although there was some commentary in the rulemaking process, which we'll talk about a little in a few minutes, that I think is to the benefit of carriers, that will help. But as for the Act itself, it's somewhat ambiguous about that. The shipper is required to provide guidelines with respect to the pre-cooling of trailers that the motor carriers to comply with, but there's nothing in the Act that requires the freight itself to be pre-cooled. And as we know, if you put warm stuff in a cool trailer, the trailer will quickly become out of temp, and the temperature from the warm goods will increase the ambient temperature in the trailer. So that's an issue not addressed by the Act. Another thing in the Act is training. There's pages and pages of language in the Act that deal with the proper training for those involved in the transportation of food and applicable materials. It describes how each entity in the supply chain has to provide training to specific people. For drivers, from the motor carrier's perspective, the Act requires that the drivers be qualified to handle specific types of loads. A lot of this, again, is going to be dealt with between the shippers and carriers and brokers by contract. With respect to record keeping, there's requirements that the parties keep records with respect to training of their employees. With respect to shippers, this also would apply to temporary or seasonal workers involved in the supply process. They still are required to be trained, and records are supposed to be kept with respect to their training. Again, we talked about the motor carrier has to keep records of the prior washing of the tanker for bulk shipments, and it has to keep records for its last 3 loads of bulk shipments. And there's also provisions in the Act that deal with when loads are suspected of being adulterated, what the motor carrier's responsibilities are supposed to do in that, what they're supposed to be in that regard. It's basically the provisions of the Act state that if there is any suspicion of adulteration, the transportation process is supposed to stop, and the record-keeping process in that regard is supposed to begin. There's also a 12-month retention period for all the records related to the Act and the training. And I wanted to talk about some of the practical issues associated with the Act, and again, going back to the issue of liability, which is the primary concern for people on the webinar, and for someone like me who's tasked with defending motor carriers in these types of claims, or if you're representing or insuring anybody else in the supply chain, whether it's shippers or brokers. The issue is, does the Act, like I said before, does it impose an additional or a supplemental liability regime on the motor carrier? Does it replace Carmack with respect to food shipments? We all know that the Carmack Amendment requires that the claimant, the shipper seeking damages under Carmack, prove that the goods were tendered in good condition, that they arrived in damaged condition, that there were damages. Well, the issue with respect to the FSMA is proving the second prong. Is does the Act supersede that second prong of Carmack? In other words, does it move the burden from the shipper to have to demonstrate that the goods were actually damaged or injured in the process? Does the Act create a rebuttable presumption, if you will, that the fact that the motor carrier didn't comply with one of the requirements set forth by the shipper for the transportation of the goods make the goods damaged or injured at destination, and does it relieve the shipper of the need to actually demonstrate loss or injury to the goods? Because we know that the shipper bears the burden of proving loss or injury to the goods. It's not the carrier having to prove that the stuff wasn't damaged. It's the shipper having to affirmatively satisfy the second prong of Carmack and say that it was damaged. The comments to the legislation or in the rulemaking process, I think, make it clear that that's not the case. That at the end of the day, it's Carmack that still applies. Again, we're talking about interstate shipments here. Remember, the Act covers interstate and intrastate shipments. So with respect to intrastate shipments, shipments from a place in one state to a different place in the same state, the argument may indeed have some weight or merit that the failure to comply with specific requirements or regulations set forth by the shipper may indeed raise a presumption of liability under the Act. But at least with respect to interstate shipments, which are the vast bulk of shipments we're dealing with, it's clear that the Carmack Amendment still applies. And that goes too with respect to broken seals. We'll talk about that issue a little bit when we get into some cases. But I'm going to just pull up something here real quick and read it to you from the notes of the rulemaking process. It says the proposed rule prompted several questions about the impact it would have on cargo loss and damage claims under the Carmack Amendment. Specifically, there was a concern that a failure to adhere to shipper-broker specified conditions for transportation would be directly linked to adulteration or damage to food products during shipment, thereby triggering the carrier's liability under the Carmack Amendment without possibility or salvage or other loss mitigation. However, the final rule clarifies that only a failure to comply with the requirements that causes food to be actually unsafe will render the food adulterated and prohibited under the Act. So it's not just an inconsequential failure or a unilateral deeming by the shipper that because the carrier didn't comply with a particular provision are the goods rendered injured or damaged. It's definitely a lot more favorable to the motor carriers in that regard. And I guess what I'm trying to say briefly is that the Act doesn't remove Carmack from the equation. It, in many respects, you could argue that it makes it, in some aspects, better for the motor carrier if they can prove compliance with the shipper issued regular or protocols and processes, and if something arrives and is rejected, the carrier has a better argument in support of their position that the goods weren't damaged at delivery. With respect to broken seals, it's important to note that a broken cargo seal or evidence of food cargo tampering would not necessarily create a per se presumption of adulterations. One of the comments from the rulemaking process is that they advise persons engaged in transportation operations that if such a situation should arise, they need to carefully evaluate the facts and circumstances of each incident on a case-by-case basis. In other words, a broken seal under the Act doesn't automatically mean that the shipper wins in a claim for cargo damages, and that's important. The bottom line is the shipper still has to prove that the goods arrived in a damaged condition or were injured in the process of transportation. The Act doesn't provide, as many feared, as I indicated earlier, it doesn't provide that statutory absolute liability against the motor carrier in the situation where a shipper could credibly argue that something may be adulterated. The shipper still has to prove loss or damages. The problem arises, though, as we'll talk about at the end with contracts, is that the motor carriers in their contracts with the brokers and shippers can put themselves in a situation where they remove themselves from the provisions of Carmack and expose themselves to the different liability regime imposed by the carriers. So that's a key point for motor carriers when they're dealing with these types of situations, when they're dealing with shippers under the Act, and when claims adjusters are handling claims in this regard. You need to look at the contract, and where you could argue in normal situations, well, you have, if you're arguing to the shipper when examining the claim, well, Mr. Shipper, this stuff may have been out of temperature for a few hours or a few days during transportation, but you still have to inspect the goods at delivery and prove they're damaged. You need to make sure that there's not a contract out there that waves out of Carmack and has a different set of liability standards where a situation like that would indeed expose the carrier to liability. So although in a broad sense the Act doesn't obviate or supersede Carmack, the Act also strongly encourages, indeed in many cases mandates, the existence of contracts to deal with these situations, and those contracts could have the effect of making Carmack inapplicable to these types of claims and making it far easier for the shipper to prove damages. And more importantly, making it much easier for the shipper to avoid the duty to mitigate and unilaterally declare that something is unsalvageable, thereby making the claim a lot more expensive than it ordinarily could be or would be. So let's talk a little bit how the Act applies to brokers and what some of the duties to the broker with respect to the broker are. I want to talk about brokers first before we talk about carriers and shippers, because the Act it basically includes brokers and shippers under the same category as they're defined. So the shipper is required to provide the information necessary for the safe transportation of the goods to the broker, and the broker is also required to make those requirements known to the motor carrier as well. It's the broker's responsibility to know what products are subject to the provisions of the Act, and it's the broker's responsibility to reach out to the shippers to get the proper protocols to give to the motor carriers and to pass them along to the carriers. The contracts need to be revised that exist now between the carriers and the shippers and the brokers and the shippers and the carriers that deal with these things. The brokers must specify to the motor carrier all the necessary sanitary conditions and specifications. They must also give to the carrier the pre-cooling specifications for certain products. The broker doesn't have to do this on every single load if it's the same product that's being shipped. A one-time notice to the motor carrier for a particular shipper and a particular product is sufficient. They don't have to provide these protocols on every shipment. So I think that's an important thing to remember. And here's an example of some shipper-broker contract language. Shipper must inform broker prior to the tender of freight of protocols for the handling and transportation of any freight that is subject to the Food Safety Modernization Act and its accompanying regulations. So that puts the onus on the shipper to tell the broker, but at the same time, the broker has the onus of telling the carrier. And if the broker isn't provided the information from the shipper, the broker has to go back to the shipper and get that information. I already talked about the effective dates of and the applicability of the Act. I want to skip over this because I talked about that a few slides earlier. I want to talk about how the Act affects shippers. And again, I said that the Act puts a primary burden as far as the protocols for safe carriage of food goods and other goods under the Act with the shipper. The shipper is required to develop protocols and to put the protocols in writing, preferably through the contracts with brokers and carriers. And they're required to ensure that the brokers and carriers are aware of those requirements. Some of the things the shipper has to do, it must determine the appropriate transport, it must set forth the operations for transportation of the goods. It must develop and supplement written procedures to ensure that the equipment in the vehicles used in the transportation product or process are sanitary. Shippers of bulk food products must develop and implement procedures to prevent cross-contamination. As far as temperature control protocols, they may be contractually assigned, but the shipper, again, is in the best position to know this, and that's why they're the ones tasked with telling the broker and carrier what the parameters are for shipment. And it says, what can you do for brokers? It's really what must you do with respect to brokers. And that's, like I said before, you have to get the protocols from the shippers and convey them to the carrier. Your contracts have to require from the shipper that the protocols are provided, and the contracts with the carriers have to require that the carrier is in compliance with the specific shipper protocols. And again, all the issues that we're dealing with should ultimately be addressed and dealt with by contract, but as we know, in many cases, that's not always the case, but that's clearly the way to deal with most of the issues associated with the Act. With respect to carriers, the carriers have to get the protocols from the shippers. And that's really an issue here because although this act has been on the horizon for a long time and everybody's seen it coming for a long, long time, what I think the general state of the industry is that the shippers have been very, very slow to put forth the protocols for the carriers' use. And the carriers have been kind of muddling around waiting for these protocols to be issued by the shipper, and is putting them in a bad spot should a loss occur. So that's kind of the state of the industry right now, is the shippers have been slow to provide the protocols to the carriers, and therefore it's been difficult for the carriers to provide to draft proper contractual protection. Carriers who rely on a tariff for regulate the contracted carriage need to revise their tariffs to reflect the responsibilities that they have under the Act. They have to deal with with the special provisions unique to the Act. The contracts that they have with their carriers need to be amended to reflect the fact that even though the shippers have protocols for temperature-sensitive goods, it's important for the carriers to negotiate in their contracts reasonable ranges of temperature variance for these shipments. A lot of times goods are rejected because a bill of lading may say that the temperature is not to exceed 36 degrees. And the temp tail at delivery will show that for a little while it was at 38 degrees or 48 degrees, and then those goods are rejected. And then it becomes an issue as to whether or not those goods were actually damaged and whether or not the rejection was reasonable. If you contract around that by saying that there are reasonable variances that by themselves don't demonstrate damage to the goods, then the carrier is protected in that regard. The motor carrier needs to have methods in place to verify that the protocols promulgated by the shipper are actually followed. They can't say after a loss, yeah, we followed the protocols that the shipper gave. There has to be written record that the various specific protocols were kept. That way, if there's a loss, then they can say to them, go back to the shipper and say, well, we followed your protocols and this wasn't our fault. There are also private entities that are emerging in the environment now to fill the gap, to adapt some uniform food safety protocols And the idea here is that it's almost like joining with a rules tariff. You can certify, you can apply for and get certification from an independent third party that you're compliant with various aspects of the Act, and then you can show that compliance certificate to the shippers to satisfy the provisions and protocols of the Act. So there are lots of things the carrier can do, but again, the most important thing is to protect themselves either with a tariff or by contract to make sure that there are all the contingencies and possibilities related to temperature variance and broken seals and things of that nature are dealt with by contract. I want to deal with some case studies now. As I said before, there hasn't been any opinions issued interpreting or dealing with any specific issues under the Act yet. And what we all deal with when we deal with situations involving food product claims, I would say that the vast majority of these claims involve situations where, like I said before, the shipper rejects a shipment because of some variance in temperature or a seal being broken. And the carrier then argues to the shipper, well, geez, you have to demonstrate that these goods are damaged, therefore we need to test these goods or test the product to make sure that there was actually damage. We need to verify it. And I want to go through some cases now and kind of discuss the difficulties and vagaries involved in these types of claims. And if you handle claims, cargo claims dealing with this specific types of cases, you often get pushback from the shipper or from the claimant or from the subrogated insurer trying to prove the damage. And sometimes they rely on cases or make arguments, and I want to go through some of the cases to deal with the specifics of it. So if you are involved in these types of situations, you know how to deal with them. The first case is Atlantic Mutual Insurance Company versus CX Lines LLC. And this was actually an ocean shipment. It was under the Carriage of Goods by Sea Act. So while it's not directly applicable from a statutory standpoint because it deals with an ocean shipment, the principles and the language used in the opinion, I think, are important for demonstrating how these types of claims and lawsuits can go. The loss concerned a container filled with 720 5-gallon plastic buckets of concentrate used for Pepsi. And this container was stored in the hold of a cargo ship, and it was on its way on the ocean, and they had to flood the cargo hold for safety reasons, and this particular container got flooded. And these buckets were sealed. They were 5-gallon buckets like you get at Home Depot, except these had metal lids on them with metal handles. And there was no dispute that these buckets of the concentrate were actually under seawater for several hours. And the only indication that there was any contamination or exposure to the buckets was a little bit of rust on the handles to these buckets. And when the goods were delivered, Pepsi rejected them and said, we're not going to allow you to inspect these or test the product in there because of a trade secret, and we don't want to compromise our secret formula. So they did a test in secret, and they didn't let the defendants know about it. Ultimately, the trial court found in favor of the ocean carrier, but then the appellate court reversed and found in favor of Pepsi. Basically, the court said, well, the evidence of the rust on the buckets was sufficient to demonstrate the possibility that the goods inside the sealed containers were damaged. So it gives you an idea that it goes to show you how difficult these types of claims are, even in the situation where there was no opportunity for the defendant to inspect the goods, and there's no evidence offered by Pepsi that the entire shipment was damaged. and there was no evidence that there were any cracks or holes or breaches in any of the seals on the buckets themselves, Pepsi was still able to prevail by arguing that there was a possibility, as demonstrated by the rust on the handles, that these goods could have been contaminated. The Penske Logistics versus KLLM case is also an interesting case in that the shipper, in this case, again, it was Pepsi. They put their product in a refrigerated trailer. The reefer unit was actually never turned on. And at arrival at the destination, when they opened the doors and they realized that the reefer was never turned on, the load was rejected. They didn't test. They didn't even take the temperatures inside the trailer. They didn't take the temperatures. They didn't take the ambient temperature outside the trailers. It was a May day. There was no testimony that these goods were ever out of a particular temperature range. The Pepsi representative basically took a look inside the trailer, saw that the reefer wasn't on, and rejected the load. And their motion for summary judgment was denied because the court found that, regardless of the fact that the reefer unit wasn't on, you still have the burden, Mr. Shipper, to demonstrate that these goods were actually damaged. So that's a contrary result of what we just talked about. These cases, as you can see, are fairly fact-specific and unfortunately very judge and court-specific at times. A case that perhaps many of you have heard about is the Land O'Lakes versus Superior case that involved a load of butter. And it's an interesting case in that the driver was driving through the mountainous region of Pennsylvania and his brakes failed and he had to go up one of those runaway ramps. And although the driver of the tractor trailer broke his back in several places and knocked all his teeth out in the accident, remarkably the trailer he was pulling remained completely intact. The seal on the trailer doors remained intact, and the reefer unit continued to function. The shipper rejected the load and refused to salvage it. So the issue here, this wasn't a condition at destination case, although it's frequently cited as one. It's more of a mitigation case. The court found that it was unreasonable for the shipper to fail to accept the goods as salvage. And it's more, but it does show you that here we have a situation where the truck was involved in an accident. But the goods inside, the butter was in plastic bags inside cardboard boxes. There was no evidence of any contamination. The boxes obviously got dented and banged around in the accident, but the goods inside were still, the butter inside was still good. So the court said, yeah, you can't reject this. You have to take it as salvage, even though they rejected it just because the truck was in an accident. So it's an interesting result. And it just goes to show you that these types of cases can go both ways. Another case involving cheese is the Oshkosh versus Gray's trucking case. And this, I think, goes to show you the importance of seal integrity and how the courts deal with this. This was a situation where it was a load of cheese that was delivered in a reefer trailer. There was no issue during the transportation process that the goods remained in temp. The truck driver arrived at the destination, checked in, signed his paperwork, and avoided several signs saying, "Do not break the seal, only we can break the seal." So he backed his trailer up just a few short feet from the destination dock and, disregarding all the signs not to break the seal, got out of his tractor, broke the seal and opened the trailer doors, and then backed up to the dock. And when he got to the dock, the goods were rejected. And the issue there was, geez, we all know what happened here. How could these goods possibly have been adulterated or contaminated just because of this minor violation of protocols by the driver? But the court ruled that under contract that was between the parties, that if you break the seal, it's going to be rejected, and he broke the seal and the goods were rejected. So it just goes to show you that these cases are very fact intensive, and where you think that, okay, in a situation like that, the shipper still has to prove that these goods were damaged, even though the seal was broken. The contract said it, the seal's broken, the shipper can reject, and that's what happened. The last case we want to talk about is the Mecca and Sons versus White Arrow case. This has to do with a load of cheese tendered to or destined for Trader Joe's, and the load of cheese was supposed to be kept at 40 degrees. And there was evidence presented during the course of the case that about half the time the stuff was being shipped in the trailer, it was over to 40 degrees, and it got as high as 60 degrees. Well, the load was delivered and rejected. The defense expert looked at it, tested it, and said there is absolutely no damage. There's no evidence of any type of adulteration, and there was actually expert testimony that said that the cheese would have had to have been kept at these excess temperatures for several days to have been affected by this, and the few hours that it was over temperature didn't matter. And the court said, well, that doesn't matter. Summary judgment granted in favor of Trader Joe's and the shipper. And the reasoning behind that is the court made a big deal of the fact that this was a contract case, and the terms of the contract clearly set forth the shipper's right or ability to determine when goods are damaged and declared lost. And the court went into a big deal about how the importance of food safety in the supply chain trumps the motor carrier's legal arguments with respect to damage. Basically, the court went as far as to say that Trader Joe's can't possibly take the risk of putting these goods into the stream of commerce, even though there's no direct evidence there that they were adulterated by being out of temp for a little while. Another thing the court dealt with, and I think it's important to acknowledge and realize when you're dealing with these types of claims, is that if you're defending a claim or responding to a claim from a manufacturer of some perishable item that has to be refrigerated, and it is out of temp for a little while, but there's no physical evidence of damage at destination, or the shipper refuses to allow the testing to happen, one of the arguments that the shipper can make, and it does hold water and the courts have accepted it, is that the fact that the goods were out of temp for a little while shortens their shelf life. In other words, if you have cheddar cheese, for example, that has a shelf life of 2 weeks and an expiration date, say of June 1st, and because it's out of temp for a little bit of time, the argument can be made that now the shelf life is not June 1st, but it's May 20th. Well, there are damages there because for 10 days, Trader Joe's isn't able to sell that cheese, and they're denied the sale of the product, so there are damages. The court noted that prolonged shelf life, in the Mecca and Sons case, the court noted that prolonged shelf life is indeed an injury to the product that is compensable. So again, these cases, you see these arguments made all the time when you're defending or responding to these types of claims, and it's important to note that they're very fact intensive and they're very dependent upon specific contract language, particularly with respect to seal integrity and temperature requirements. Now again, going back to the food safety, the FSMA, the act itself doesn't change anything in that regard. It actually forces the parties to deal with these issues by contract, which is actually a good thing. It's not the feared Armageddon for motor carriers as it was initially contemplated when the act was first discussed. The fact that the shippers and brokers have the onus, having familiarity with these products, to set forth the protocols and require that the carriers follow the protocols is a good thing, I think, for carriers. If they don't follow them, and if the carriers for some reason aren't able to follow the protocols, it's not necessarily evidence, doesn't support a prima facie case for loss or damage. There's still the karmic standard, and I think that's what's most important. Okay? And finally, we're almost done here. I want to just talk about cargo insurance and how it applies to what we just talked about. We talked about the fact that there's the Carmack Amendment that governs the rights and remedies for damage for goods in interstate commerce. We talk about contracts, how the parties agree to either waive out of Carmack or change the liabilities and responsibilities of the parties outside of Carmack, particularly with respect to temperature control or seal integrity. So the carrier can be liable under Carmack, or the carrier could be have breached a provision of the contract regarding carriage and be liable in that regard. But at the end of the day, if the cargo policy issued to the motor carrier doesn't cover that particular loss, then it doesn't change the fact that there's no coverage. And I think that there's often a fundamental disconnect there between what the statute says, what the contract says, and what the policy issued to the motor carrier actually provides. And it's very, very important for motor carriers to review their insurance policies to make sure that the additional requirements and duties that are going to be imposed upon them by virtue of the act and by virtue of the fact that the shippers are going to be mandating all these protocols that the carrier has to follow, they need to make sure that their insurance policy tracks those types of requirements so that if they fail or if goods are damaged, the policy doesn't contain a specific exclusion for that type of thing. So I just wanted to make an important note of that disconnect, because again, if the carrier is liable under contract or under Carmack, but there's no insurance coverage for the carrier, then that creates a whole different set of problems. So that concludes my presentation. Thank you for paying attention, and for those of you who nodded off, it's time to wake up. You can send me emails at jwesco@wglaw.com with any questions, comments, criticisms, or observations, and I'll be happy to respond to you. You can learn more about this program and all of the Weber Gallagher events at www.wglaw.com/WG-University. Thank you all very much, and have a great weekend.